While deciding my application for suspension of sentence, the learned Sessions Court, acting in its appellate jurisdiction, has rejected my application for exemption from depositing the 20% penalty amount, which is as per Section 148 of the Negotiable Instruments Act statutory. Now, I'll just give my lords the impugned order, that is Annexure P1 on page 18. We get convicted under Section 138. We move an appeal before the Court of Sessions, and there are two applications which we filed. First application was for suspension of sentence. Of course, we were on bail by the trial court itself, so it was for confirmation. And second was to exempt us from depositing the mandatory, so-called statutory mandatory 20% as per Section 148. Now, suspension of sentence application was allowed. If my lords could just see page 19, the relevant part of the impugned order which we challenged before my lords. Because this is the second paragraph from the bottom. अपीलार्थी की ओर से तर्क प्रस्तुत किया गया कि प्रश्नागत चेक चंद्रकला रिट्रीट फर्म द्वारा जारी किया गया था, जिसे अभियुक्त के रूप में संयोजित नहीं किया गया एवं अभियुक्त आरोपी से इस फर्म के प्रोप्राइटर होने के बारे में कोई दस्तावेज पेश नहीं किए गया। प्रतिपरीक्षण में यह प्रकट हुआ कि परिवादी ने चेक पर अभियुक्त के हस्ताक्षर की पहचान नहीं की है। इस प्रकार फर्म की प्रोप्राइटर प्रीति गोकलानी है, ना कि कपिल गोकलानी। अतः प्रथम दृष्टया अभियुक्त निर्दोष है। अतः मामला अपवाद स्वरूप है। अतः उपरोक्त न्याय दृष्टांत के आधार पर, दैट वाज द जजमेंट वी वर रिलाइंग अपॉन ऑन टॉप, आधार पर 20% प्रतिकर राशि जमा करने से छूट प्रदान की जाए। Now the judgment says, my lords, that rule is not absolute, and in certain cases this 20% can be waived. I'll show that judgment to my lords at the end. If my lords may just permit me to give a little more of the facts. I have filed both the checks in question. One is on page 27. Now, my lords will see the issuer of the check, or in other words, the person who is issuing the check is the proprietor of Chandrakala Retreat. My lords will see the seal of that. And of course, there is a signature. My lords may just note that. The second check, this is valued at 11 lakhs. The second check is valued at 5 lakhs. That's at page 32. Again, the same situation, my lords. Check has been issued by Chandrakala Retreat. And my lords may just note the signature because it will be relevant when I show my lords two lines in the cross-examination.
Who is this person signing it?
This person, my lords, we claim is P. Goklani, Preeti Goklani, who is the proprietor of Chandrakala Retreat. I am not the proprietor of Chandrakala Retreat. That was my defense before the trial court. And the trial court, I'll be just taking, my lords, very briefly into that part of the evidence where the complainant categorically admits that he cannot identify whose signature this is, and he cannot state who is the proprietor of Chandrakala Retreat. Based on this, we say the principal ingredient of 138 is not made out, and that is why it is one of those rare and exceptional cases where the conviction may be in fact legally perverse. And that is why the 20% waiver is what we were claiming. If my lords may just have the evidence of the complainant, I'll just show my lords those relevant admissions for the point in question. The evidence has been filed for my lords, but the relevant portion is page 43.
Now let's see that judgment you are relying.
Yes, my lords. That is in the reference column I've uploaded for my lords. Para 6 of the Supreme Court judgment says, what is held by this court is that a purposive interpretation should be made of Section 148 NI Act. Hence, normally the appellate court will be justified in imposing the condition of deposit as provided in Section 148. However,
this is not to be blindly followed. In appropriate cases, it can be relaxed.
Yes, that's all. That where there is, if in fact para 7 gives us the crystallization. Therefore, when the appellate court considers the prayer under Section 389 of an accused who has been convicted for an offence under 138 NI Act, it is always open for the appellate court to consider whether it is an exceptional case which warrants grant of suspension of sentence without imposing the condition of deposit of 20% of fine or compensation amount. As stated earlier, if the appellate court comes to the conclusion that it is an exceptional case, the reasons for coming to the said conclusion must be recorded.
You are husband of Preeti Goklani?
No, I happen to be the son.
Son of Preeti Goklani.
Son of Preeti Goklani. What we submit, my lords, is the prosecution story is like this. That they claim, although we have a counter to that, we say that all the money was returned, but that will be decided in the appeal. What we say right now is that the checks have been issued by Preeti Goklani from an account which was drawn from an account which is in the name and style of Chandrakala Retreat. When they were presented, they were dishonored. Now, our contention is, my lords, the case would have been absolutely legal had the case been Chandrakala Retreat through their proprietor, that is Preeti Goklani. Of course, that would have put them into a difficult spot because there was no legally enforceable debt between the complainant and Preeti Goklani. That legally enforceable debt was between me and the complainant. So there was actually no remedy which ever lay with the complainant under section 138. It was always a civil suit which was for the complainant. But, my lords, utilizing this misnomer in law, he has gotten this 138 matter registered against me, which I just want to show, my lords, that why he needs to show that it is why he cannot show that Kapil Goklani, who is the petitioner before, my lords, and the convicted accused, has got nothing to do with the account on which the check was drawn. Now, if my lords may just have page 43 of my petition, my lords, once again. That is his evidence. I'm showing, my lords, his categoric admissions. My lords will see there's a para 15 of his cross-examination. I'm just reading one line, which is the third line in para 15, specifically stating, मुझे जानकारी नहीं है कि चंद्रकला रिट्रीट का proprietor कौन है. Now, if my lords will see, onwards of the fourth line of para 17, that is just a couple of paragraphs below.
Daniel,
My lords.
would the relevant consideration under section 148 be the financial condition or the merits of the case?
It must be the merits of the case, my lords. Now, what I contend over here is a 138 prosecution was not even maintainable against Kapil Goklani, leave alone a conviction. Now, that will be decided whenever the appeal is heard. But right now, the trial court says that there's a fine amount of 28 lakhs. That is with interest, 16 lakhs. In total, they valued it at 28 lakhs. I will be required to deposit about 7 lakhs. That is Kapil Goklani. And if my lords will see the cross-examination ahead, he's
Not 7 lakhs, 5.5 lakhs.
my lords, 20%, something like that. My lords may pardon me. But it will be in an amount in the high lakhs. Now, what I submit before my lords is, I am not even a legitimate party. My conviction is absolutely illegal because my lords will just see in paragraph number 17, he categorically states, third line from the top, ये कहना सही है कि प्रदर्श P2, that is the check, के दस्तावेज में चंद्रकला रिट्रीट लेख है, प्रदर्श P2 के A से A भाग में अभियुक्त के हस्ताक्षर हैं, ये सही है कि प्रदर्श sorry, my lords, this is page 43 only. Then, my lords, in para 17, this is the fourth line from the bottom. Very importantly, this witness, the complainant himself states, ये कहना सही है कि प्रदर्श P2 के दस्तावेज चंद्रकला रिट्रीट अभियुक्त की मां के नाम से है. He knows about that. स्वतः कहा कि मैंने प्रोप्राइटर के बारे में नहीं बताया. यह कहना सही है कि प्रदर्श P2 के A से A भाग में P गोखलानी के हस्ताक्षर हैं. स्वतः कहा कि मैं किसी के हस्ताक्षर नहीं पहचान सकता. Now, either which way, either he claims it to be P Goklani, which is not me, or he claims he can't identify the signature. Either both of the situations, my lords, are in my favor. 18, he says, ये कहना सही है कि P5, that is the second check valued at 5 lakhs, के दस्तावेज में चंद्रकला रिट्रीट की सील लगी हुई है. साक्षी से पूछे जाने पर कि प्रदर्श P5 के ऐसे भाग पर किसके हस्ताक्षर हैं, तो साक्षी ने व्यक्त किया कि उनके हिसाब से वह अभियुक्त कपिल के हस्ताक्षर हैं. मुझे नहीं मालूम कि प्रदर्श P5 के ऐसे भाग पर चंद्रकला रिट्रीट के प्रोप्राइटर प्रीति गोकलानी के हस्ताक्षर हैं कि नहीं. नाउ, दिस वाज आवर प्रिंसिपल डिस्प्यूट बिफोर द लर्नड ट्रायल कोर्ट. And in fact, my lords will see the judgment. I filed the entire judgment of conviction for my lords.
Does the Supreme Court say that you have to consider the merits for 148?
No, the Supreme Court just, my lords, says that if it's a rare and exceptional case, and in order...
Where it says?
My lords, may just have the judgment once again. 6 and 7, my lords, of the same judgment I was referring to in the reference column. This is 2023, volume 10, SCC 446, Jambu Bandari versus Madhya Pradesh State Industrial Development Corporation. Paras 6 and 7. Read for my lords. What is held by this court is that a purposive interpretation should be made of section 148 NI Act. Normally, the appellate court will be justified in imposing the condition of deposit as provided in section 148. However, in a case where the appellate court is satisfied that the condition of deposit of 20% will be unjust, or imposing such a condition will amount to deprivation of the right
Daniel, the other day you were arguing about an arms act appeal.
Yes,
also there was an interim order which was not so much speaking.
Yes, my lords.
The problem before the court says that if they pass very speaking interim orders, then you may have a case that, look, they already made up, the court has already made up its mind to allow the petition, allow the appeal, or dismiss the appeal. My lords.
So the stay order cannot be so much speaking.
So the stay order cannot be so much speaking. Yes, my lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay order cannot be so much speaking. My lord. So the stay or
Maybe, my lords. What I am submitting is the stay order may not be very elaborate. It may be just indicative of the reasons. Because this judgment itself in the last part of para 7 says that some reasons need to be recorded. Because either one of the two parties will always have a right to challenge that. So some reasons may be there. My only contention before my lords is when the proceedings against me are ipso facto illegal. I can't, of course, predict the fate of the appeal, my lords, but in all prospective fairness, I say that, my lords, I stand a very good chance. Now, under these circumstances where I was not a legitimate party to the lists, it either had to be between the issuer of the check and the proprietor who was somebody else, or he may come up in a civil suit against me. And worst case, even if the complainant loses his appeal before me right now, I succeed in the appeal and he loses the case, he still has the right of a civil suit. There's no prejudice which accrues to him in any manner.
Yes. ठीक है, possible.
My submission, my lords, I just submit that this amount I'll be made to deposit, and that will currently just prejudice my case. As of now, my lords, the trial court has granted me 60 days to deposit. What I submit is, if my lords are inclined, my lords may issue notices and stay the operation and hear the other party, or as it pleases, my lords.
I consider.
Deeply obliged.